Welcome back to the final hour of the Don Carpenter Show on News Talk 1270 KIML.
News Talk 1270 KIML. Don Carpenter Show. And welcome back. We're going to go right to the phones, and I want to welcome to the show Paul Lopez. He's the director with the South Florida law firm of Tripp Scott. He's the chair of the firm's litigation department, and your specialty is employment law, right?
It is, Don. Good morning. Thanks for having me.
Good morning, and thank you for joining us. I'm glad to get to talk to someone who knows a little bit about the legal side of a topic that it's one of my pet topics, and since we do talk a good bit about these kind of stories on the show, and one of the stories, actually, I kind of want to start off with this one because I thought this one was a good sign of what is going on with a lot of privacy concerns that people have regarding their employers. Of course, I'm talking about this story from last week where a woman was fired from her company for deleting a smartphone app. And the app, of course, had a 24/7 GPS tracking feature. Of course, the company let her go after she deleted this app. Does this seem to be an issue that more and more companies are doing more and more to keep track of their employees all of the time?
Well, there's no doubt about it, Don. Companies are constantly trying to push the envelope with how much monitoring they're doing of what their employees are doing during the workday. And obviously, in situations like this Arias case, it involved this lady by the name of Miss Arias. She was an employee out in the field who was mobile, and many employers are going in that direction. And what we're seeing is that they're trying to implement software in their computer systems and in their smartphones that they give the employees, or frankly just requiring their employees to download apps to their smartphones so that the companies can track the employees. And obviously, the idea here is the company is trying to track the employee to make sure that the employee is doing their job, and they're going to, the customer's job site and how efficient they're being and so forth. But the Arias case is a very, a really blatant example of where an employer went, way over the line. Because apparently this smartphone app that they had either put on the employee's own smartphone or gave to the employee was able to track the employee 24/7, 365 days a year, and was able to track what the employee, what the employee was doing at all hours of the day, even when the employee wasn't working for the employer. So that really was just a very peculiar and unique situation where, I don't think you're going to see, hopefully not too many employers doing that, because that's certainly over the line. But the lines in the legal arena that I deal with every day, those lines do get blurred. And, the question becomes for the courts in trying to wrestle with the tension between, the employer's right, the company's right to monitor the employee's activities, and then the employee's right to privacy is, how much is too much and how much is enough, and how much of the privacy rights, should be encroached or should be allowed to be encroached by the employer. So that's an issue that we're dealing with. We're dealing with it not only with tracking employees, but in the workplace, what they're doing on the computers, internet activities, social media. It's a really interesting area of the law, Don. That is, it's a challenge every day to kind of keep up with it.
Well, and of course, one of the justifications, since you mentioned tracking what people do on their work computers and having programs that block certain websites. Obviously, the argument is, well, the company owns the computer. You're on company time. You shouldn't be doing things that aren't related to company work. But it's extended beyond that. I mean, companies are starting to watch what people do in their off time, and people are being fired, for example, for posting things, posting a off-color joke on Facebook, or posting a racy picture on Instagram or something like that.
Right.
And this is on their own time. I mean, what do we do to rein in that kind of big brother type attitude?
Well, it's a great question, and the issue is, and I consult and I provide counsel to many companies because I primarily represent companies, and what I try to tell them is, look, you have to have a legitimate business purpose or legitimate business interest in monitoring what your employees are doing in off hours. And I think you raised some good examples. For example, if you have an employee out there who is making some negative comments or some comments that could actually compromise the company's business out there in social media in their off time, well, that may be something that is, in fact, an act that could be disciplined by the company, and they could end up firing that employee. But the question becomes, what is too much? And what I always tell companies is this, and Trip Scott, we try to really tell our clients to just make sure you're being very transparent with whatever your policies are. You've got to communicate those policies to your employees. You've got to tell them that, hey, these are the things that we're going to be monitoring while you're in the workplace. And by the way, in your off hours, you should not be, for example, revealing confidential information relating to company practices or company pricing. Put that in your employee handbook. Put that into your policy so that your employees can't suggest that they didn't understand that there was some potential discipline that could come to them if they're doing some things that are reflecting poorly on the company. Now, the question is the employee's behavior related to company business or their own, personal affairs? So you use the example of, doing something on social media, maybe sending a picture, across the internet, cyberspace, which is what people sometimes unfortunately do these days. But,
Sure.
Does that have anything to do with company business? There's probably a strong argument that it doesn't. So if that person decides that, in their personal time, they think sending a picture of themselves to a friend is a good idea, and maybe it's not the most flattering photo they have, that's their own personal time. Now, let's use the example, though, of a high-level executive at a company versus, for example, maybe a hourly worker or a mid-level manager. I can see an argument being made by the company to say, wait a minute, we have a high-level executive here. If it starts getting out there that this person is exercising what we view as poor judgment, i.e., you're reflecting poorly on yourself, and perhaps that's going to be impactful to our business, and somehow customers or suppliers or vendors or companies we're doing business with are going to look disfavorably upon us, maybe that is a justification for the company to discipline an employee, a high-level executive who exercises some poor judgment in that context. So to me, it's a question of transparency, communicating those policies, and then does the company have a legitimate business interest in monitoring the employees' activities when they're in their off time.
Well, and just to use myself as an example, since I am at least on a small scale, I'm the public face of my company. If I were to go online and post some kind of terrible racist joke or something like that, obviously the company would be justified.
Correct.
Now, if I worked in a factory building cars and never dealt with the public, in a case like that, I imagine the company, maybe they, say, hey, maybe you ought to back off on the online stuff, but termination might be a little bit overboard.
It might be a little overboard, and I think that's a really good example of where maybe, depending on the employee and the position that employee holds at the company, it's a question of what kind of discipline are you going to provide the employee. And again, another thing that we counsel our clients on oftentimes is progressive discipline is generally the better part of discretion here. So maybe with an employee who is more of a lower-level employee and not, for example, the public face of the company, maybe there it's just more of a warning, a verbal warning, maybe a written warning. And then if the employee continues to persist in that type of conduct, maybe then it might lead to a discipline, that would lead to termination.
Right.
But progressive discipline is probably always the best way to go.
Okay, so and now moving on from people that are saying completely inappropriate things. Well, we'll use the example of the founder of Mozilla, of course, the web browser maker. It came out that he supported some anti-same-sex marriage initiatives. He donated some money to some foundations. And he was publicly run out of his position. Now, again, this is obviously a different kind of situation than someone who does something completely inappropriate, posting nude pictures or racist jokes or something like that. This is just a difference of opinion, and whatever you believe in that particular issue. It seems like that's a very dangerous road to start going down.
Well, I think it can be. And I think there's a good example of something that obviously is a very hot-button issue in society right now. The question of same-sex marriage. Regardless of what your opinion about that is, whether pro or con, it is clearly a very polarizing issue. And I think in the example of Mozilla, there you have a situation where because you have a founder of a company who has made a comment on such a volatile issue that potentially could lead to some serious backlash against the company, now there's a question of how is this going to impact, for example, shareholder value? How are the shareholders going to potentially be negatively impacted by that? And I think that's, again, part of the equation. The question is, is there some, real legitimate business ramification that may come from the employee's conduct? So I think hot-button issues are always going to be something that a company is going to have to look at, whether, from top to bottom, mid-level, lower-level employee, top-level CEO, the company board and the company is going to have to figure out what makes the most sense under the circumstances. And Don, this is where it gets really interesting for us because as a lawyer who does this every day, there's not a bright line test. It's not black and white. I mean, there's lots of areas of gray here, and there's lots of nuances here, and every situation is going to be different. Every situation is going to, require some sort of thought to how to best deal with the situation. What's the discipline that makes sense? Is it termination? Is it a write-up? Or is it, frankly, a no action? Because the person was on their off time, and what they were doing really had nothing to do with the business. There's not going to be any impact to the company. So, frankly, you know what? That's their person's personal time, and there's nothing we're going to say or do about it.
Well, and in this particular case, it's something that had happened in the past, and I understand it's not really within your wheelhouse to comment on whether it's the right or wrong thing, but on a legal standpoint, this is something that it's within the legal right of the company to do something like this, right?
Well, it certainly is. And look, companies have the right to hire and fire employees for no reason or any reason at all. However, there's a whole body of law that deals with exceptions to that general concept, which is, you can't fire someone for availing themselves of their federally protected rights. For example, obviously you can't fire someone based on their gender. You can't fire someone based on their race, color, creed, age, national origin. If they have a disability, you can't fire people for those types of things. However, if somebody is engaging in free speech, for example, because this is the argument that we're starting to see, is, hey, I'm engaging in free speech. You can't terminate me if I'm engaging in free speech. Well, the question is, what is the context of the speech? What is it that employee is saying? What are they saying in connection with the speech? Are they discussing a complaint that they have in the workplace about their wages? that there's an interesting opinion that came out from the National Labor Relations Board last year, which made it very clear that companies need to be very careful about coming down on employees who engage in offline discussions. And when I say offline, I mean in their own personal time, when they're discussing amongst themselves wages, by email or through social media. Because the National Labor Relations Board, NLRB, is saying, hey, wait a minute, you as a company can't come down on people when they're talking about wages, because that could be collective bargaining. You could be, interfering with their rights to collectively bargain and potentially unionize. So, we're seeing this area of the law kind of daily, change what the landscape is as far as what employees can do and say, and what's the topic of what they're talking about.
Well,
there was an interest. Go ahead. No, sorry.
I was just going to say the way technology has advanced in the past 20 years of how people communicate, that seems to have made a huge difference. I mean, back 50 years ago, if you're talking about wages, you were either at the bar after work, or you're by the water cooler at work, of course, that was already. That's already addressed in current labor law. But nowadays, it's on a Facebook group. It's by email. It's with a text message. And I think the law sounds like it. I mean, it sounds like it's catching up to that.
It sounds like it is, and it is. What we're seeing is the courts are starting to deal with this, and the Department of Labor, the NLRB, they're recognizing that the modern era of communication is really now being more prevalently, dealing with social media, Twitter, Snapchats, Facebook, Instagram, emailing, texting. This is the way people talk now every day. Again, whether you like it or not, that's just the way it is. And the courts are slowly, but they are in fact adapting to the new modern era of communication, and they're dealing with it.
Now, do you see the NLRB or Department of Labor or any other entity maybe extending some of those protections that are that they already give to labor type discussions to other kinds of free speech, to political discussion or just regular everyday discussions?
No, I don't think so. I think, we're dealing with, issues, for example, the workplace conditions, which include, wages, breaks, benefits, forms of compensation. I think that's really what the Department of Labor and the NLRB are all focused on. When you're dealing with more of a, for example, social context, give you the example of a lower level employee who gets on Instagram or Facebook and just bashes his or her manager. Okay, is that something where the company is not going to have the right to fire that employee? No, I don't think so. I think the company certainly has the right that if somebody's out there trashing a manager in a public domain, that if the company finds out through legitimate means, in other words, they're not invading the employee's privacy, but rather they hear about it through second or third hand and they investigate, that could be grounds for termination. And I don't believe that the employee would really have any sort of claim against the company. However, I use that example, but the word of caution on that example is if the company finds out about this through some illegitimate means. In other words, the company improperly accesses the employee's Facebook account through the company computer, for example, and the employee doesn't know that that's happening or that potentially could happen. Now you may have a situation where a company has, again, overstepped its bounds and has invaded the employee's privacy rights.
And since you mentioned Facebook there for a second, and this just reminded me of it seems like a few states are starting to kind of move in this direction, but we're starting to see some movement towards the idea that maybe employers shouldn't have private Facebook or private social media passwords. And I know a few states have started moving on legislation prohibiting that. Do you see that kind of movement in that direction, that Companies won't have access to someone's private social media accounts?
I think that's what we're seeing, because the reality is what the state legislatures are starting to see and recognize is that people should have some modicum of privacy with those types of sites, and that an employer should never really have the right to get an employee's password for their Facebook or some other social website that, again, has nothing to do with company business. And that's where I could come back to the examples I gave you earlier, Don, which is, the company needs to have a real business reason for monitoring the employee's activities. If there's no business reason for doing that, then I think the company is going to be hard-pressed to legitimately make a successful argument that they have the right to monitor that employee's, what that employee is doing when they're not working for the company. So I totally can see that legislatures are starting to try to recognize that employees need to have some level of freedom with what they do. Now, I will add that, for example, social media policies in the workplace, I think companies still always will have the right to tell their employees that, look, during the work day, when you're here working for us, 9 to 5, you need to be focusing on work-related activities. And I think a company can always limit what that employee does as far as on their social medias. For example, the Facebook website or Instagram. A company can restrict that during the workday, and the distinction there, Don, is we're saying that yes, the company can always control what the employee's doing and not doing in the workplace, but that doesn't mean that then the company has the right to go into an employee's Facebook to get information about what that employee's doing. And there's a distinction there, but it's a huge difference on what the courts are wrestling with as far as what a company has the right to do and how far they can go with respect to what they can monitor.
And I'll be honest, the first time I started seeing these stories of companies wanting private passwords for email and social media, I was just thinking, who thought that was a good idea? But I guess someone somewhere thought it was a good idea. I think maybe they didn't quite understand how some of these things work. But
right.
It has always interested me. I mean, luckily I've never worked for a place that had that kind of policy. And before I got in radio, I did work for some trucking companies that would track the truck 24/7, but not me. If I wanted to go somewhere, they knew where the truck was, but they didn't know where I was. So I always thought that was the truck's their property. I wasn't. So
correct.
That's the difference. So where do you see? I mean, the next we'll say the next 5 years. I mean, where do you see this this field, this privacy in the workplace field? What direction do you see it moving in?
Well, I think it's hard to predict, and obviously 5 years in the age of cyberspace and information age we live in, it's so hard to predict. But here's certainly a certain trend that we're watching and that we're seeing, is that I think what the courts and the legislatures are going to try to do is to provide us all with some more clarity about where these lines are drawn. I think the example you used earlier is a really good one about legislatures in several states that are coming up with bills and laws that prevent an employer or company from getting and requiring an employee to give that company the employee's password. That's certainly starting to define what the boundaries are. And I think what we're going to see is we'll see more bills and more laws come into effect on a state-by-state basis. Federal, probably not as much, because that's always much harder to get things done on a federal basis. But on a state-by-state basis, I think we'll see more laws in states that start giving us some more clarity as to where those lines are. How clear those bills are going to be and how clear those laws are going to be is hard to tell. But I think we need that because, the question of privacy, it's such a esoteric and subjective test. So what you may think is private, I may not think is private information, and I think we wrestle with that in the context of privacy rights and how much of an expectation you should have of privacy. And that's another another issue we haven't really talked about. But the question for employees always is, what is the reasonable expectation of privacy you should have, and how much disclosure is given to you by the company with respect to your expectation of privacy? All of that is part of developing a good, comprehensive policy for the company, for the workplace, what kind of environment you're going to have in the workplace, and make sure that your employees know and have a pretty clear understanding of what expectation of privacy they should have. So I think we'll see some more laws along those lines, Don, as best as we can tell at this point.
Well, I will say it is a fascinating field. I mean, it even for a layman like me, it's fascinating to watch how some of these cases progress. And we're almost completely out of time. Or do you have anything that you'd like to a website for the firm or anything you'd like to promote before we wrap up?
Well, sure. I appreciate that, Don. If anyone has any particular questions about this area, you can always reach me directly at pol@tripscott.com, and that's my law firm, and I'm happy to field any questions from any of your listeners about this area. But, what I would always tell any listener of yours is, look, just find a lawyer who does this every day. There's too many people that they practice what I call internet law. They try to Google for information to how to answer clients' questions, and boy, that's just a recipe for disaster. Me and my team over here, we do this every day. We're looking at the cases. We're actually in the arena. Just be careful of who you're getting advice from. Just find someone who's really got some real good experience with this area of the law.
Well, I will say probably the only thing more dangerous than an internet lawyer is an internet doctor. So, trust me. Anytime I always like to mess around with my doctors. I'll say, "Hey, I saw this thing on WebMD," and the face just drops. But sure. Thank you so much again, Paul Lopez from Tripp Scott, the chair of the litigation department. It's a fascinating discussion, and hopefully, maybe next time one of these cases comes up, we can talk to you about it.
I'd love to do it, Don. Anytime. Thank you again for having me.
Thank you very much. Again, Paul Lopez from the law firm of Tripp Scott, and he's the chair of the litigation department. It's fascinating stuff. It really is. We need to take a break, though, so we'll be right back. News Talk 1270, KIML.
He's not bald.
That's a solar panel for a talk radio machine. Don Carpenter on News Talk 1270, KIML.